Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about divorce and family law. Joining me once again is my co-host Jesse Barrientos. Jesse, how are you?
Good, Dave. How about yourself?
Very well. Good to see you.
You as well.
Well, divorce and family law. I know you have a lot of these cases in the hopper right now, so this is something that you deal with almost on a daily basis. For our viewers out there who want to know the difference between an uncontested divorce and a contested divorce, where's the starting point on that?
Well, contested means that the parties are not in agreement. Uncontested means that they are in agreement. And probably if it's a friendly type of situation, if you could say a divorce is friendly in any sense of the imagination, and the parties have already agreed on what they're going to split up and on who is going to be the primary caretaker or have physical possession of the children, it's going to save you a lot of headache, a lot of time, and a lot of money if you could agree on those issues. And even you could even go to a mediator. I'm a mediator as well in DuPage, and a mediator can help the parties kind of bridge the gap if there's maybe a couple issues that they can't agree on. But then the mediator can't then represent one of the parties. They'll have to go someplace else. Mediator's job is to help the parties come to an agreement. The mediator is in control of the process, and the parties are in control of the outcome. You always want to be able to have an input in what that outcome is, rather than have a judge who is going to listen to pretty much a thumbnail sketch of your life, of the evidence, of all that stuff, and then make a determination. Now, neither party is going to be happy. One party might be a little less happy than the other party, but unfortunately, that's just the way that it goes.
Right. I get calls from people sometimes saying, yeah, we both agree on the divorce. And then when I delve in a little further, well, do you agree on custody, support, visitation, division of property, allocation of debt? No, we haven't talked about that. We just agree on the divorce, so it's uncontested. And they just have the nomenclature all off.
Right. And again, uncontested divorce means that you're agreed on all of the issues, because realistically, a divorce is dividing up the pie. Whenever you get married, think of it as one marital estate, and generally, everything, all the assets that are acquired during the course of marriage are marital. All the debts that are acquired during the course of the marriage are marital debt. And so really, it's a matter of dividing up the pie equitably. Also, if there are children involved, or minor children, then it also becomes a matter of, again, who's going to have the physical possession, physical custody of the children most of the time, where they're going to live, and then what's the visitation schedule going to be like.
What's the time frame, start to finish, on an uncontested case where both parties agree on everything?
Probably within 45, maybe 60 days. It could be a little bit longer, depending upon how complex the issues are. What has to happen is the same documents need to be drafted: a petition for dissolution of marriage. When you do something that's uncontested, a lot of times of course, the attorney will represent the person that first came to him, and he does not represent the other person. The other person is encouraged to get an attorney, but the folks want to save money. So the attorney drafts the documents, generally sends them to the client to make sure that the documents are as they discussed, and then that person will give them to their spouse to review them and to execute them, and then to send it back. So, with that exception, it might take a little more time. Also, there's a requirement for parenting class in all the counties that people have to take. That will cost you $75, $85, depending upon where you're at, and that's important in all cases where there are minor children, because the judges aren't going to waive that, and although they might go ahead and grant the dissolution of marriage, if the person that hasn't taken it, they'll suspend visitation until that person has completed the class.
Right. The office just completed a case today where the judge did grant the dissolution, but gave 28 days for the couple to complete the parenting class, or the judge was going to vacate her judgment.
Right. Well, you need some kind of motivation, because if once the divorce is done, if you didn't have to worry about that, then the parties aren't going to spend the money. And really, it's not it's more a parenting class to school the parents, to make them more knowledgeable on what their children are going through in a divorce situation. It's not necessarily parenting per se, but in that special window and circumstance of divorcing parents.
Do you think a judge would actually vacate the judgment in Cook County if the parties did not complete the parenting class within the 28-day period?
You know, he could, and if one of the parties happened to get married in between that time, there'd be a real issue. I think that a lot of things could happen. I think that the judge could issue a rule to show cause against them for indirect civil contempt for failing to obey their order, and could execute the minimus, which means if they haven't complied, can incarcerate them. I mean, there's one judge in Will County that if you haven't completed your parenting class, he will issue a rule to show cause.
Will he grant the judgment, though, prior to the class being
Generally not. The problem we have is in situations where one person has completed the parenting class and the other one hasn't, or there's maybe a default judgment and the other person hasn't filed their appearance or their answer, and that person hasn't taken it. But visitation or parenting time is provided for within the judgment for dissolution. And that's a situation where I've seen judges, hey, okay, look here, Mom, you've taken it, great, no problem. But here's the visitation schedule, but it's not going to be enforced until the other party completes and files proof of completion with the clerk.
Okay, let's talk about a contested case in terms of the time frame, what a person could be looking at in terms of fees, in terms of the structure of the case, and what they can basically expect in a general nature in a typical contested case.
Well, that kind of depends on whether or not custody is involved, or custody is an issue or not. If custody is an issue, you open a whole nother can of worms. Let's take the easier one first. Let's say that there are no children, or custody is not an issue. So basically, if the parties aren't in agreement, they're not going to be in agreement on maintenance, formerly called alimony. They're not going to be in agreement on child support, although it's statutory. They're not going to be in agreement on the division of property, or the division of their retirement accounts, or the division of whatever else they might have that might be an issue. Maybe somebody has a couple of classic Harley motorcycles, right? And the person wants to keep them, but hey, they all have a value, and the other person, if they were acquired in the marriage, is entitled to his or her equitable split of those motorcycles. So it can take a long time. Realistically, after you file your petition for dissolution of marriage, then you have the summons sent to the sheriff. The sheriff then serves, or a special processor serves the respondent. The respondent now has 30 days from the date that they received the service of that petition for dissolution of marriage and summons, within which to file their appearance. And there's a fee to file your appearance. And their answer to the petition for dissolution of marriage, basically admitting or denying each specific allegation in the petition for dissolution of marriage.
They could also file a counterclaim alleging certain facts that the petitioner did upon the respondent.
Right. A counter petition for dissolution of marriage. But I will tell you this, generally the reason why people file those is if one person just filed a petition for dissolution of marriage, that person, all the way up until the time of trial, can withdraw and dismiss their petition on the payment of filing fees to the other side. So a lot of times the other side will file a petition or a counter petition for dissolution of marriage to prevent the other side from doing that.
Yeah, I'm glad you mentioned fees. There's a new law that passed with regard to fees. I don't know if you're familiar or not as of yet.
Extra $3.
Extra $2 for each side, one-time fee to go to a special fund to help pro se and veterans.
I think it's called Access to Justice, if I'm not mistaken.
This was initially going to be a $10 fee for both the appearance and the petition, reduced down to $2.
Well, I said $3 because it's going to cost an extra $2 for filing the petition, and an extra $1 for the person filing their appearance.
I think it's 2 and 2.
My understanding was 2 and 1, but you could be right. So in any event, that's going to generate a ton of money that's probably going to be nowhere to be found in any event.
Right, and I don't see why this has to go towards pro ses. They should be encouraging people to hire counsel with something as complicated as a divorce. I don't think the judges want a bunch of pro ses running with contested cases.
Well, remember the old adage, person who represents himself has a fool for a client. And that's true in a lot of respects. It's because the person doesn't know what the law is. And that's, lawyers are trained to deal with that stuff. Also, because they don't know what the law is, they make a lot of mistakes, and the judges have to deal with that and take extra time, and they're going to be held to the same standard as an attorney. Now, that doesn't really happen. I've seen judges give great leeway and latitude. One of the judges in Will County has a pro se day that other attorneys volunteer, and as these contested cases come up, they'll either go and help the parties kind of mediate it, or write up an order, or do different kinds of things to assist the judge. I know in DuPage there is night court, and then there's also a specific courtroom that's dedicated to pro se, and that's just when there's pro se on each side. In other words, the people are representing themselves. Once a lawyer gets involved, then it gets reassigned to whatever courtroom.
Okay. It just seems like the fees are getting a little bit out of control. You're talking about $500 or $600 total between an appearance fee, a petitioner fee, and a court reporter fee. This is on an uncontested case. If a couple wants to use one attorney, they're going to have $500 or $600 in court costs alone, which takes up not very much court time and not much clerk time either for an uncontested case. So maybe there needs to be a bifurcation on whether it's going to be a contested case or an uncontested case, because it's a huge disparity and it's not really fair.
The problem is that agreements can turn sour and go south over anything. You could have an agreement, things could be going fine, and then one party gets ticked at the other party, and maybe they withhold the child from seeing the other parent, which is not appropriate, because the children, it's all about the best interest of the minor children, not about what's convenient for the people.
Well, that's where the judge should flag it as no longer an uncontested case, because it's not being proved up within 90 days with one court appearance, and mandate that the additional fee for a contested case be paid, because now it's going to take a lot more court time. I mean, this may be a novel idea to you, but I really think it's getting ridiculous. As the fees keep increasing, people who want access to the court in a simple, agreed upon, amicable way are paying the same freight as someone who's going to waste 2 to 3 years of the court's time. Think about that.
Well, I have, and I guess maybe probably the bigger question is to think before you marry.
Well, hey, that's the toughest thing in the world to do, because
Well,
love is a strange animal.
That's true, but here's the deal. Marriages are treated very cheaply these days because you can get a divorce. It didn't used to be that way, I don't think, a long time ago. But nowadays, hey, you can get a divorce and run with it, no big deal. But, of course, you're going to pay.
Yeah. Well, there's divorce court TV shows where they actually pay the litigants to come on their show and air their dirty laundry. So anyway, that's another topic. Let's talk about custody briefly. You touched on it, but let's really dive in a little bit. If custody is going to be in dispute, there's a standard that the court uses to determine who is going to have custody of the child or children. What is that standard, and explain it to our viewers?
Well, it's the best interest of the child or children. And what's going to happen if
best interest is the child's with me?
Of course,
that's what the party's going to say.
That's one factor. They're going to look at one of the things on, what are the desires of the parties. That's real easy. You want the kid, I want the kid. Okay, that's fine. So that takes care of that. They're going to look at the wishes of the child. However, it's just one factor. It just doesn't take, the older the child is, the more weight that their desire is. But if you have an infant that's 12 months, 24 months, then obviously there's going to be no weight. The child really can't make that kind of a decision. They're going to look at a history of any type of domestic violence between the parties. They're going to look at any other factors that would help the court make that determination.
He drinks. He gets high. He stays out all night. He's got friends that do the same thing. They don't want the child in front of the father with his friends.
They smoke cigarettes.
Is this all a
There's
legitimate
no bed for
reason?
the child. Those are legitimate reasons, but unfortunately, a lot of times...
She's a pole dancer. Is that a legitimate reason?
Well, I guess you got to work, But the problem, though, is that sometimes these excuses are just thrown out there to muddy the waters to see what sticks. Okay. They are all legitimate concerns, because when it comes to the child, hey, those are all legitimate concerns. But again, and so since you've mentioned that, a lot of times one party will inappropriately get an order of protection to, first of all, have that other party not see the child, but also to get exclusive possession of the house. And so now what happens, that person gets kicked out of their house.
This is an important point. Explain to the viewers how easy in certain circumstances it is to obtain an order of protection and what that does to the party that it's issued against?
There are certain allegations that have to be made in the petition for order of protection, and it's pretty much stratified wherever you go, and there are people, advocates, that help you complete those type of things, but ultimately it's up to the judge to grant. You can obtain an order of protection if, for example, maybe you shoved me, but then we're also talking about a domestic battery, maybe yes, maybe no. Or maybe you prevented me from leaving. Maybe you took my car keys away. Maybe you texted me 100 times within a half an hour.
Maybe you threaten to kill me if I don't stop dating who what?
That's also correct. So what happens is the person goes in with these allegations and they're under oath, and they go before the judge, and it's ex parte. That means it's one-sided. And basically that person is saying, I'm fearful that if I give the other side advance notice that they're going to harm me because of what I'm alleging now.
Oh.
And then the judge...
That sounds unfair on its face.
Well, that's the way the Illinois Domestic Violence Act is written. So what'll happen is go before the judge, and the judge will look at it. Now, I think that probably the judge errs on the side of the child, or if there are children involved in that.
And there's a reason for that.
There is a reason for that. There's a lot of reasons for that.
Self-interest.
Well, I don't know, Dave. I think that, hey, when you weigh the pros and cons of it, what if I'm wrong? I'm gonna weigh it a little heavier, again, in the best interest of the child. Because what's going to happen, though, once that emergency order of protection is entered, the other person has to be served with it. And then there's going to be a hearing within 21 days to see if that emergency order of protection turns into a plenary order of protection. Emergency is less than 30 days, 21 days, as I said. It can be extended by agreement, or if there are issues, the court can extend it if they can't do the hearing. And then a plenary is over 30 days, more like 6 months, a year, 2 years, to be able to have that. The terms can be modified because a lot of times they go along with divorce. But then what will happen is if they get granted the emergency order of protection and get served, that means part of the remedies are exclusive possession of the house or the apartment or wherever you're at. You can't have visitation with the kids, and basically you can't go back to the house. The police may escort you to be able just to get your sundry items, some of your clothes, but it's really horrible. Imagine just going to work and then, okay, you get your order of protection, and now all of your stuff is at home. But you can, if you do get an attorney, you can file a motion for an expedited hearing very shortly thereafter, within 4 days, if you have it served, to have your hearing so that you don't have to wait the full 21 days.
So you better hope you have a family member or a friend or
Someplace.
some money to get a hotel.
Right, someplace to go. Unfortunately, that's the way it is. And my problem is that a lot of people really abuse it. Again, if people lie, they lie. There's not a whole lot we can do about that, or even the judge. But they use it to get a leg up in the divorce, and then it'll be proceeded. Then there'll be a divorce filed, and then during the course of that divorce, the allegations of the order of protection then comes up, and I already have physical possession and custody of the child now, so it's easier to proceed that way than to go uphill to say, now I want custody.
Okay. Let's segue into visitation. Let's say we have a contested case. Right now, one party has temporary custody. The other party is seeking temporary visitation. What could they expect in terms of time frame and amount of parenting time with their child?
Well, just so our folks at home know, come next year, the Illinois Marriage and Dissolution of Marriage Act has been revamped, and so they're going to be doing away with some terms like visitation. It's going to be referred to parenting time. A lot of jails, and I'm a jail as well, will say parenting time. And again, visitation has just a kind of a negative connotation that, somehow I'm less than a parent. I've heard that said. But parenting time, because both parties exercise parenting time. And so a standard parenting time schedule is that the non-custodial parent has the child or children every other weekend overnights, and there's a lot of other things that are involved. Depends upon their age, depends upon their needs, and different things of that nature. Maybe once during the week for dinner, something like that, and then you'll have these other holidays that the parties will split equally. Sometimes, depending upon odd or even years, one person will have the first half, the other person have the second half, and the same is true for summer vacation as well. And then the holidays generally alternate. One year you'll have them for Christmas, the next year I'll have them, or sometimes sometimes people celebrate Christmas on Christmas Eve. And maybe it's not an issue, so maybe you get them every Christmas Eve and I get them every Christmas because we celebrate Christmas on Christmas, and you may celebrate that on Christmas Eve. So there's a lot of different variations, but generally that's just kind of a standard parenting time schedule.
So in the next couple of years, we might lose the phrase, quote, reasonable visitation, unquote?
It'll just be reasonable parenting time.
Okay.
Well,
it's just a play on words because you parent someone when you're not with them as well.
That's correct.
You're not just parenting when you're with them. So it's a little bit of a misnomer as well.
Well, it makes sense then, parenting time. A lot of people think, right now, there's joint custody and sole custody. Right now, as we sit here today. Joint custody means that the non-custodial parent, the parent who doesn't have physical possession of the children most of the time, has a say-so in the upbringing of the child as it relates just to three areas. As it relates to religion, as it relates to education, as it relates to medical decisions. Well, the older the child, generally those things don't really matter because if you're religious or you're Catholic or you're Christian or you're Jewish, you've already been doing those things, so that's not an issue. As it relates to education, generally if they're already in private school or if they're in public school, that's where they're at. Medical, it doesn't refer to obviously those emergency decisions. It refers to elective type of things like maybe orthodontia. Sometimes I've seen situations where maybe there's a special needs child and experts are involved and the other person, the non-custodial parent, wants to say so in discovering and finding a specific expert for the child. And then also what the opinion is. Maybe they want to get a second opinion as to what the diagnosis might be. So those are really kind of few and far between that way. But
what about the tender years, doctor? Now that's different because
we'll get back to that in a second. And then if you talk about sole custody, it means the opposite. The non-custodial parent doesn't have the say-so in those issues. But it doesn't mean people think that, okay, well, if I get sole custody, I've lost my rights. No, you have all the same things. It's just those three issues that you don't, that the other person has carte blanche on.
Well, you might have lost the decision over extracurricular, whether Johnny plays football, whether the person takes piano lessons or dance class. You might have lost that too if you don't have custody. Joint.
If you don't have joint, but joint custody is right now, again, because it's going to change, is only appropriate for parties who can come to an agreement as it relates to the children. A lot of people can't do that. A lot of butting heads, and the court can't grant joint custody. They can't do that. It's going to be sole custody. Somebody's going to be
out.
Right.
Okay.
And that's why I said earlier, hey, it's better if you have a decision in, or say so in the final decision, rather than have somebody else make that decision for you that you're not going to like. But again, you still have all of those things, and part of the things that the new law is going to do is going to take out those type of things, and maybe it's going to allow one person to have say-so in maybe this area, that area, and the other person. And again, hey, it hasn't come out yet, but this is kind of what we expect that is going to happen.
Okay, let's talk about child support. Sometimes people fight for custody because they don't want to be the party who has to pay child support. But let's say you are the person who has to pay, and the court is going to order it, and they're going to order it to come out of your wages if you're an employed person.
Correct.
A W-2 employee.
Right.
What can you expect? You said it was statutory. Is
Right.
that without any leeway?
Well, there's always leeway. Right now, the statute has the statutory guidelines. For example, for one child, it's 20% of your net. For two child, 28%. And it goes on up the line all the way on up to 50%. So depending upon how many children that you have. But realistically, let me just say a word here. If that's your child, you need to support that child, okay? It's so important.
They want to support the child, but they don't want the money going to the custodial parent to misuse or misappropriate in other areas that don't go to the child.
That happens all the time. There's no accounting. I hear that all the time. But that's the way it is. But it's for things like a roof over that person's head. It's for the bills. It's for food. It's for all kinds of different things. And by the way, just because you're paying child support, you're also going to be on the hook for maybe the sitter, maybe daycare, or those other type of things. Those are separate expenses over and above the child support that you're going to be paying.
Yeah, because mom's back out on the scene.
Well, if she's going to work and then there's a sitter, well, of course, that's appropriate. If she's not working and there might be an issue there not to pay for for any type of daycare.
I meant the nightlife.
I see.
Mom is back on the scene. She's entertaining. She's going out. She's hobnobbing. She's buying stuff for herself to make herself
Too bad.
look better, and
bad.
the child is going hungry.
Well, that's a different issue. You could file a motion, and maybe a garden line will be appointed. But there's no accounting. There's no accounting for that. But realistically, that's
It is
your
something we
obligation.
hear, though, on
It's
a
something we
regular
hear all the
basis.
time. All the time.
You know, the kid's dirty,
Right.
the clothes have holes, the food that's being provided is horrible, and mom's living it up, or dad's living it up.
Mm-hmm.
And you really can't stop it unless you go in on a motion and try and prove that this is happening, and it's very difficult.
Yeah, and time consuming too. But if you talk about deviating from those statutory guidelines, sometimes maybe if it's a special needs child, we were talking about that earlier, and more attention is required, or more medical or something of that nature, then the court can certainly deviate over the guideline. Or let's say that the one spouse makes a ton of money. The child doesn't need $500,000 a month to take care of them. So that's, super high salaries are another reason maybe to deviate.
Right.
The other party is going to be fighting over that for just the reasons you said, because they get the ultimately carte blanche on the money they have. Another reason to maybe deviate, let's say you have a home and there's equity in the home, and you've allowed the other spouse who has the children to keep the home, and so the equity as well. So, hey, that's a reason that we would deviate. We would make sure that it's very specific in the judgment and in the marriage settlement agreement to that effect. But there are other reasons to deviate from the statutory guidelines as well.
Okay. What about attorney's fees? You hear callers say, I want him to pay my attorney's fees. He makes a lot of money, I don't. You have other cases where they both make the same amount of money, yet they're wondering what the judge is going to do vis-a-vis attorney's fees. What can they expect in that regard?
Well, we live under the American system, which each party pays their own attorney's fees. However, in the marriage and dissolution of marriage field, there's a leveling the playing field. So if there's an interim petition for attorney's fees or for final fees, and one person makes 5 times as much as the other spouse, then there's probably going to be a contribution. However, if that spouse is paying maintenance to this other person, that's kind of has leveled everything off, and so there might not be a contribution of attorney's fees, or maybe just a small portion of that contribution might be ordered. Again, each case is as unique as they come, and you just have to look at the facts of each specific case as you go along. It's very important to go to somebody who is very knowledgeable about domestic relation issues.
And with all these issues we're talking about, it's always best if you can agree amongst yourselves, as opposed to putting it in the hands of an impartial judge who doesn't know you or the facts or anything like that.
That's correct. It's always better to come to a decision, because then you've taken part in it, you have stock in it, you're more likely, realistically, to follow it as well.
Okay, let's talk about hourly rate. We just have a minute to go. What are the typical hourly rates that someone would encounter for a contested divorce?
$250, $350, $325, $375, $400, and there are some attorneys out there that bill at $500 an hour. They have a lot of years of experience, and it has to go with the uniqueness of the case as well. The more complex it is, if it's a lot of properties, a lot of assets that are involved, then it's more complex, and so those fees are warranted.
And that might convince someone to try and negotiate a settlement when they realize that each party is going to be paying a lot of money towards their fees, correct?
Absolutely. It might even be a college tuition.
Okay. All right, Jesse, thanks so much for joining me.
You're welcome.
A wealth of knowledge over divorce and family law. Hope you enjoyed the show. We'll see you next time on Legal Action. Take care.